Ladies and gentlemen, once again, welcome to the Kakasungura YouTube channel. A big thank you to each and every one of you for your continued support. If you're watching this video for the first time, kindly make sure you click that subscribe button and remember to turn on your notification bell. Ladies and gentlemen, as I told you since yesterday, I will be camping here to give a breakdown on what is happening in the Supreme Court, where now the defense side has taken up the petition that was filed by the Azimio One Kenya Alliance Party, led by Senior Counsel James Orengo. Today, this morning, ladies and gentlemen, the Senior Counsel and the seasoned lawyer and the former Attorney General Githu Muigai has misled the court this morning. Na nataka niweke mambo hayo kwa uwazi, wapenzi watazamaji. There are things that when are being submitted, I told you I will be here to break it down for you. I have been listening to the submissions given by Senior Counsel Githu Muigai, and I was asking myself if indeed Githu Muigai understood what he was really speaking about. Did he listen to himself before making such a submission? Because he was telling the honorable judges that the lawyers from the defense side, we have elected governors, we have elected members of parliament, and elected senators. Remember, Okiya Omtatah is now an elected senator. James Orengo is an officially elected governor, among other defense lawyers who are currently in elective posts. Now, Muigai is arguing that if the presidential election was marred with multi-practices, it means the whole exercise, including that of member of parliament, including that of senator, including that of governor, should also be declared null and void. I am not a lawyer, but I believe the judges are always guided by the previous cases that have been successfully won. In this case, I have seen them refer to the Maina Kiai case that was used to determine the nullification of the presidential election in 2017. So, in 2017, it's only the presidential election that was nullified. And if indeed the presidential election had errors, as per the argument of Githu Muigai today, then in 2017, we could have also nullified the result for president, the result for governor, senator, women representative, and MCA. A quick question to Githu Muigai. I don't know if you will get a hold of this video, but I believe in one way or another, in the next couple of hours or minutes, this video will reach him at the Supreme Court. But then I want to quickly ask him some questions, and I want to clarify this issue from Githu Muigai, ladies and gentlemen. When a voter goes to the polling station, is given separate ballot papers. The MCA ballot paper is separate, the member of parliament ballot paper separate, the governor ballot paper separate, the president ballot paper separate, and all the 6 elective positions, their ballot papers are separately marked by the voter. Is our honorable senior counsel aware that you can manipulate an MCA result separately while that of a member of parliament is intact? For instance, let me give an example of polling station X. A voter has moved into the polling station. He has been given 6 ballot papers. Ya MCA, ya MP, governor, senator, women rep, and the president. The voter will mark these ballot papers separately. And even in keying in the result in Form 34A, all the results are separately keyed in. The Form 34A for the president is separately keyed in from Form 34A of that of member of parliament. In this case, following this explanation, one is able to manipulate a presidential result alone in that particular polling center, while that of a governor is intact because they are not entered into one form. Wacha nizungumze kwa Kiswahili ndio watu wanielewe vizuri. Nasema hivi: mtu akienda kupiga kura katika kituo, anapewa zile karatasi 6 kando. ya rais kando, ya mbunge kando, ya gavana kando. Anapoenda kupiga kura, anapiga kura zote zikiwa kando na anaziweka katika boxes tofauti tofauti. Kwa hivyo kama mtu ana haja na matokeo ya ugavana, anaweza akayabadilisha ili hali yale ya mbunge yakisalia vile vile yalivyopigwa na yule mpiga kura. Na wanapoelekea katika ile fomu ya 34A, wanapojaza yale matokeo, fomu ya mbunge huwekwa kando, fomu ya gavana huwekwa kando, fomu ya woman representative huwekwa kando. Kwa hivyo kama ningetaka kufanya mabadiliko katika fomu ya mbunge peke yake, inawezekana. Haingewezekana. You know, the Githu Muigai argument could have made sense if a voter was given one ballot paper that contains an MCA, that contains a government rep, that contains a president, such that we argue that in this same form, how could one manipulate an MCA result and that of a president remains intact? That could have been the argument. But as far as, and by the way, is Githu Muigai aware that we are dealing with a result from Bomas and not a result of an MCA that was announced in the Funyula award? Is this senior counsel aware? Why is Githu Muigai stooping this low? Ladies and gentlemen, is a senior counsel, a former attorney general, an experienced seasoned lawyer who should argue with facts at the fingertips. I expect him to educate us on how it's possible for the judges to nullify all the elected positions, yet they were separately elected. So as far as I stand from this platform, Githu Muigai has lied to the Honorable Court, and I expect a question from the judges, the Honorable judges. I'm waiting for that question. I'm waiting for Philomena Mwilu. I'm waiting for Smoken Wanjala. I'm waiting for the CJ Mother Kome to ask a valid question and ask Githu Muigai to respond to us. How is it possible for one to nullify all the elected positions, yet they were separately elected? That is the question I want him to respond. Ladies and gentlemen, the submission from Githu Muigai is below average, as by my own assessment. In 2017, is only the presidential election that was nullified, because we are dealing only with the form that underwent a server. Na result ya MCA, my friend, si inamalizia kwa kituo na wanatangaza kwa constituency, hata iende Bomas inaenda tu just for file keeping. Results ya mbunge inakuwa announced at the constituency tallying center. Kama inaenda Bomas, inaenda tu for the record purposes. Ladies and gentlemen, but then for tallying purposes, the original Form 34A, that of a president, goes through the server to Bomas, where it's given a final tally to Form 34B and Form 34C that is used to declare the president. These are the tough questions we want the lawyers from the defense side to put us clear, to explain to us, so that Kenyans of goodwill who are following this case can extensively understand this case, ladies and gentlemen. And I want to guide my followers from this platform that if the court is guided by the previous case, that is, if it's, I have seen Githu Muigai making a reference to the decisions that were given by the judges in 2017, where the court ruled that the Form 34A from the polling center is final and Bomas is only tallying and verifying. So the question in court by the petitioners is, the IBC failed to carry a verifiable exercise, because from the evidence in place, from what we tallied here the previous days, it indicates there are a number of arithmetical errors, which proves that the exercise was not verifiable. Point number 2. the petitioners are accusing IBC of not being transparent. In this case, you remember they have already denied Azimio access to the servers. That's a gentleman. They claim they have 8 servers and they need authority from either the CEO or Chebukati himself for them to open the servers. So by the virtue that they have denied the Azimio part access to the servers, it means there's something they're hiding. And I am told, it's an unconfirmed report, but then I'm told that the company that was used to code the Kiam kits has refused to grant access with claims they allege that it goes against their rights. Ladies and gentlemen, this is an indication. You remember in 2017 they said their servers are in France and no one can travel there because of limited time. Ndio ile mchezo ya paka na panya imeanza. Yes, ile ya 2017, ladies and gentlemen. We are dealing with accountability. The 6 commissioners, led by the deputy vice chair, Madam Cherera, they accused Chebukati of hiding Form 34C in Bomas. Chebukati is on record that he never announced 28 clean constituencies. That rendered the exercise unaccountable. The issue of transparency. Transparency means when everybody is satisfied with the result. The agents of Azimio were locked out. They were not given time to access the Form 34C. That rendered the exercise not being transparent. The commissioners argue in an audio posted in this platform where they are requesting Chebukati to give them access so that they can at least see Form 34C they sign after seeing and verifying before they append their signature. Chebukati refused. That means the exercise wasn't transparent. I will come here to listen the submissions from the defense, and I will be breaking them one by one as they proceed. I'm waiting. I'm really waiting how the judges will be handling the submission by the senior counsel, Githu Muigai. Ladies and gentlemen, keep subscribing and keep watching this video. I wish you the very best as you listen to the case. Thank you so much.